Hello and welcome to ProfDale's Property Videos. My name is Dale Whitman and I've been teaching property courses in law schools for more than 50 years. In these videos, I'll try to present the main topics of the property course in a way that's clear and understandable and that everybody can grasp. While the videos are designed primarily for law students, they can also be helpful to people in the real estate and banking industries, and of course anyone is welcome to watch them. Each video is about 15 to 20 minutes long. The first topic is adverse possession, and there are 4 videos on adverse possession. The first of them, the one you're watching now, is an introduction to the basic concept of adverse possession. Video number 2 will deal with the required elements or behaviors that an adverse possessor has to exhibit in order to acquire title to the land. Video 3 will deal with conditions that inhibit or prevent an adverse possessor from getting title to the land. They prevent adverse possession from arising. And finally, video 4 will deal with the tacking of successive adverse possessors and will also briefly cover adverse possession of personal property. In this first video, we're going to talk about the basic concept of adverse possession. And the concept is simple, although it's quite surprising. The idea is that if you trespass on somebody else's land, and you do it for a long enough time, and you do it with the right behaviors while you're on that land, you can actually become the owner of the other person's land. In other words, adverse possession is a way to become the owner of someone else's land without buying it, without paying anything for it, and without obtaining a deed. It's really quite extraordinary. Now, before we dive into adverse possession in detail, there are some words that you need to know. So we're going to do a little glossary of those words here. The first word is title. And when most people hear title, they think of a piece of paper, something like the certificate of title for a car or other motor vehicle. But when we say title in real estate law, we're not talking about a document at all. We're talking about the law's conclusion about ownership. In other words, if we say that John and Mary Jones have title to their house, what we mean is that the law concludes they own the house. We're not talking about any particular piece of paper that they might have reflecting their ownership. So title can't be touched or read or felt. Title is a legal construct, not a document. A deed, on the other hand, is a document. It's a piece of paper, and it acts as a conveyance of title from one person to another. We call the person who is giving up title the grantor, and the person who's receiving the title the grantee. And the deed operates to transfer or convey the title from the grantor to the grantee. Now, a deed is an inter vivos conveyance, and by inter vivos, we simply mean between the living. In other words, a deed can only operate if you have a living grantor and a living grantee. A chain of title means a whole group of deeds that extend back from the present owner to some sovereign government that originally gave the title up long ago. Usually the sovereign government is the United States of America, but it might be, if you lived in the southwestern U.S., a Spanish or a Mexican government land grant that originated the chain of title. It's also possible that a chain of title might not go back to a sovereign at all, but instead might go back to an adverse possessor, because, as we will see, an adverse possessor is thought of as getting a brand new original title to the property, which they can then pass on to someone else and create a chain of title of their own. Recording refers to the fact that in nearly every county in this country, there is an office called the Recorder of Deeds or Register of Deeds, and their purpose is to receive and maintain copies of deeds and mortgages and other instruments or documents that affect the title to land within that county. If you have a deed, you can record it with the County Recorder of Deeds, and if you want to know if somebody else has title, you would go to the Recorder of Deeds and do what we call a title search, in which you look for the documents that affect the title to the particular land that you're interested in, and you can assemble those hopefully into a chain of title for the land that you might want to buy, for example. So that's all done in the Recorder of Deeds office. Recording of a deed isn't legally obligatory. There's no requirement if you get a deed to land that you record it. But it's certainly true that recording is a very, very good idea. Color of title is also a document, but it isn't a valid one. Color of title looks like a valid document, something that would give you ownership of the property, but there's something wrong with it. It's defective in some way, even though on its face it appears to be okay. Common examples would be a deed with a signature that's a forgery. It isn't really the signature of the owner of the land, or a deed that was never delivered, or a deed that's got a defect or error in its legal description so that it doesn't really convey the title to the land in question. So color of title looks good, but isn't. Finally, there's the concept of the bona fide purchaser. That's someone who buys the property, pays value for it, and doesn't know about any defects in its chain of title. There might be some defects, but a bona fide purchaser doesn't know about them and has no reason to know. In other words, the bona fide purchaser is what we might call an innocent purchaser. Usually we abbreviate that just BFP. Now back to adverse possession. Adverse possession is based on the running of the statute of limitations. What's a statute of limitations? Well, it's a statute that says that if you have a civil claim against someone and you don't bring that claim and file your suit within some fixed period of time after your right to sue arises, you lose the right to bring the suit. Your right to receive the benefit of the suit expires, and if you get the suit filed, the court will simply dismiss it. Now, adverse possession is based on the running of a statute of limitations for a particular action, which is called ejectment. Ejectment is a way of throwing somebody off your land by going to court if they're trespassing on your land. Ejectment was one of the English common law forms of action. In the Old English legal system, you not only had to have a claim on which relief could be granted, but you also had to call your claim by the right name, and ejectment was one of those names. It was what you'd call your action if you wanted the court to throw a trespasser off your land. For example, ejectment was widely used against Irish peasants during the potato famines of the early to mid-1850s. If the Irish peasants couldn't pay their rent, the landlord would go to court, file an action in ejectment, and have the court evict them from their property. So the result of ejectment is an eviction order from the court. Now, if an adverse possessor stays long enough on the property with the right behaviors, the statute of limitations will run in an action for ejectment. No surprise there. That means that the true owner can no longer sue the trespasser. But amazingly, adverse possession means much more than that. It means that the adverse possessor now has a new title to the property, and the title of the old true owner is expired or terminated, and they no longer own the property at all. So the adverse possessor becomes the new owner. The adverse possessor is not liable for anything they did during the period of adverse possession. They're not liable, for example, for being a trespasser, for damaging the property, for collecting rent from tenants during the period of their adverse possession. In other words, it's as if they were the owner all the time. So we say that adverse possession relates back to the date of the inception of the possession. In other words, we treat the adverse possessor as if they've always been the owner from the date that they moved onto the land. Now, adverse possession seems like legalizing thievery, and so we might ask ourselves the question, why the law recognizes it. If we go back to England before the 20th century, it's easy to understand why they had adverse possession, because there were no public land records in England. People would keep their deeds in a box in their closet, perhaps, but there was no public way to record their deeds. So as a result, land titles were often disputed, And one of the best ways of establishing that you owned a piece of land was that you had possessed it for a long period of time. So without public land records, it's easy to see why adverse possession was a very useful concept. But in America today, we do have public land records, and so that means that it's a little harder to justify having a doctrine of adverse possession. There are some arguments for it, however, and let's list a few. You can decide if you're convinced by them or not. First, you might say adverse possession encourages people to improve land, that is, to cultivate it, to build buildings on it, to make it more valuable. And it certainly does have that effect, because if you go on someone else's land and improve it, and you're there long enough, the land, including the improvements, will become your own. And so that certainly encourages you to improve land. A second argument is that adverse possession punishes people who sit on their rights. If someone moves on your land and is there for a long period of time and you don't do anything at all about it, you must not care much about your land. You're not very interested in it, and you're certainly not being very aggressive in protecting it. And so we might say that it's just fine for the law to take the land away from you if you don't think more of it than that. Another argument is that adverse possession helps to establish disputed property rights. We'll see an example of that in a minute, where adverse possession can be used to settle a boundary dispute between two adjacent owners. And adverse possession is clearly very useful for that purpose. Finally, we might say that adverse possession protects lengthy reliance. If you're on a piece of land, even though it doesn't belong to you, for a long period of time, you, your family, your friends, your neighbors will tend to assume that you own it. And so in a way, what adverse possession does is to establish that the reliance of your neighbors and friends, for example, turns out to be correct, that you do end up owning the land, and that means that what they relied upon turns out to be true. Now, there are three common situations where adverse possession arises, and we're going to look at an example of each of these, but first, let's list them. The first one is the case in which the adverse possessor believes that he or she owns the land, they bought it, they paid for it, but it turns out there's a defect in their chain of title. The second situation is where the adverse possessor is encroaching on the neighbor's boundary by building a fence or a wall or a building over on the other side of the line where they don't own the land. The third possibility, and this one is the rarest of the three, but occasionally it does happen, is the adverse possessor is trying to steal somebody else's land. They actually intend to acquire title to land that they don't originally own. Well, now we're going to look at an example of each of these three common cases. The first one is the defect in the chain of title. Remember, we talked about chains of title before. A chain of title is a set of deeds or wills or other documents that go from the sovereign government through a series of owners down to the present owner. In the example that we have on the screen, we have the sovereign deeding to A, who deeds to B, who deeds to C, who deeds to D. So D believes and intends, expects to be the owner. The problem is that the deed from A to B, way back in history, it might have been 50 or 100 years ago, is missing. Nobody can find it. It doesn't exist in the public records. No one can find it in an attic or in a closet or anywhere else. It's simply not there. And that means that D's title is suspect, because D doesn't have a complete chain of title. But if D satisfies the requirements for adverse possession, the result is that D will end up being the owner of the land by virtue of the adverse possession, and the fact that the old deed from A to B is missing doesn't really matter. So that's a very helpful concept from D's point of view. It confirms what D believes and intends, and it's a very valuable and useful thing that adverse possession does for us. The second situation is the boundary encroachment. Here we have A and B side by side, and you can see the actual boundary between their two lots is the solid line with the arrow pointing to it here. That's based on the descriptions in their deeds, or perhaps it's based on a recorded subdivision plat if A's and B's lots are in a subdivision. it's easy to establish, and a surveyor could come out and mark that line on the ground and put some stakes at the corners so that everybody could find it. But A decides to build a fence, and A doesn't have a surveyor come and find the location of the boundary. Instead, A simply goes out and maybe guesses where the fence is and puts it 5 feet over onto B's property. Now, as soon as A does that, we've set up a situation for A to trespass on B's land. So if A goes over onto that 5-foot strip and mows the lawn or plants a flower garden or a vegetable garden, or even more obviously, if A builds a shed or a house on that 5-foot strip, then A is an adverse possessor. If A continues to do that for the required period of time, A will become the owner of the 5-foot strip and B will lose it. The result is that B's property is a little smaller than it used to be, and A's property is a little bigger. Now, is that fair to B? Well, you might say if B is that heedless of people who come on B's property and build fences or build buildings or plant flower gardens, then B doesn't really deserve to keep the 5-foot strip. It's no great loss to B to take it away from B if B is that careless about who's on B's land. There's an interesting little variation on this theme. If you're in a state that requires an adverse possessor to pay the taxes on the property in order to establish their adverse possession. There are a handful of states that require payment of taxes. Most states don't. But if we're in a state that does, you might ask the question, if A goes over on that 5-foot strip of land and adversely possesses it, can A claim to have paid the taxes on it? And the answer to that is almost certainly no. And the reason is the taxing authorities, the assessor or tax collector, whatever he might be called in the particular state, will assess the taxes on the basis of the legal parcels as shown in the deed description. So A has one parcel and B has another, and B almost undoubtedly will be paying the taxes on all of B's parcel, including the 5-foot strip. So the result is that in a state that requires payment of taxes, A won't be able to establish title to the strip by adverse possession, and B will be able to keep it instead. Now, the third situation is what we might call the squatter, the person who simply moves into a house or other building, decides to stay there as long as they can. Perhaps if nobody kicks them out, they'll be able to stay long enough to acquire title to the land by adverse possession. Squatters don't do this very frequently, but sometimes it does happen, and it works. The squatter does end up with title to the land. Now, we've been talking about the period for adverse possession, but we haven't said how long it is. So how long do you have to stay on land in order to be a successful adverse possessor? Well, in England, the statute, which was passed in 1623, said that an adverse possessor had to remain on the land for 20 years. There are quite a few American states that also adopted the 20-year period and still have it today. But the most common period in the U.S. today is 10 years, and you'll find more states that use a 10-year period than any other period. The range of states, however, is quite wide in the United States today. The shortest period is 5 years, and the longest period is 25 years. So you just have to look at the statute for the state that you're in and see what the period is. Some states have a special shorter period if certain extra facts are shown to be true. And these aren't very common, but you will find them sometimes, so let's list them. First, if the adverse possessor has color of title. Remember, that's a deed or other document that appears to give the adverse possessor ownership of the land, but the deed or other document is defective. Well, it may be defective, but it may allow them to use a shorter period to establish their title by adverse possession. Second, some states say if the adverse possessor pays the property taxes, they get a shorter period. Third, there are a few states that say if the property is a city lot rather than being acreage out in the countryside, they get a shorter period to establish adverse possession. Finally, a few states say if the adverse possessor fences or encloses the land, they'll have a shorter period to establish their possession. So all of these are variations on some basic period that will be found in the state's statutes. How does an adverse possessor acquire title? Well, the first question we might ask is, when do they get title? And the answer is they get it immediately and instantaneously the moment that the required time period has elapsed. We're assuming they have been in possession for that time period with the right behavior. When the time period is over, they have title to the land automatically and instantly, and the old true owner loses their title at that same moment. Their title expires or terminates, and they no longer have an ownership in the land. Is a court proceeding necessary in order to show adverse possession? No, it isn't. It's automatic and no court proceeding is necessary. It is true that you can have a court proceeding if you want. We'll talk about that in just a moment, but it isn't essential in order to have title by adverse possession. Is adverse possession a transfer of title from the old true owner to the adverse possessor? Well, the answer theoretically is no, it's not a transfer. It looks a lot like one, but the theory is that the old true owner's title is extinguished and the adverse possessor's title is a brand new title, not a transfer of the old owner's title. Does the adverse possessor get any writing to reflect this acquisition of ownership? The answer is that generally they don't. In fact, there is no automatic way to create a writing showing that they are a successful adverse possessor. As I sometimes like to put it, when you complete your adverse possession, the adverse possession fairy doesn't fly through the window and drop a deed in your lap. You own the land, but you don't have any writing to evidence your ownership. Now you might say, does an adverse possessor need any writing? And the answer is, well, they might. Imagine that you are a successful adverse possessor, you've completed the time, and now you are ready to put the property on the market and sell it to somebody else, which you have a perfect right to do. However, the person who's thinking about buying your land might go to the courthouse to do a title search, and they'll come back to you and say, wait a minute, you don't own this land at all. You don't have any chain of title going back to a sovereign. You don't have any chain of title whatsoever. So why should I buy the land from you? And you might respond by saying, well, because I'm an adverse possessor. That's why I was here for the required time period with the right behaviors, and therefore I own the property. And the person who's going to buy your land might say, well, that's a very interesting theory, but how do I know it's true? How do I know you were really there for the required time period? How do I know your behavior on the land was correct? I'm not so sure I want to buy your land at all. So the chances are that the adverse possessor won't be able to sell the land even though they own it. Now, there is a way to get a writing, and the way in most states is called bringing a quiet title action. If the adverse possessor brings a quiet title action, they'll need to go to court, make defendants in the action out of the former true owner and anybody else who had an interest in the land, and then in court prove the time period that they were on the land and prove that their behavior while they were there was the correct behavior. If they do all of that, the court will issue them a decree, a quiet title decree, stating that they own the land. And now they'll be able to exhibit that to anybody who wants to buy the land, and they'll be treated as having a valid title to the property, and they'll be able to sell it. I hope you enjoyed this video. This has been the first of several videos on adverse possession. The remaining ones explore some advanced topics and also explain briefly adverse possession of personal property. If you'd like a further source for study, I'd recommend the Property Treatise by Stobuck and Whitman, published by West Academic. If you have feedback or questions, I'd enjoy hearing from you. You can email me at profdale01@gmail.com. Thanks for watching.